I've always felt very strongly about it, and I've been watching very carefully what others have been doing.
Records show that a forensic audit initiated by the Prince of Wales flagged an undisclosed offshore transaction linked to Queen Camilla's Mediterranean voyage aboard the superyacht Esperanza. 3. Queen. This was not a private family squabble or a minor lapse in royal etiquette. What Buckingham Palace press releases attempted to pass off as a routine summer excursion was in reality a documented breach of the Crown's financial transparency framework, involving corporate lobbyist assets. The implications go far beyond personal reputation. By activating a forgotten 2005 pre-nuptial financial protocol, alongside an emergency Privy Council order, Prince William executed a cold, legally binding intervention that systematically stripped power from the Queen's office without a single public debate. This was an institutional purge designed to neutralize a direct threat to the constitutional legitimacy of the throne. Before we analyze the financial disclosures and the unredacted registry files, let us trace how a single maritime filing unraveled the delicate balance of power within the House of Windsor. During a routine compliance audit conducted by the UK Maritime and Coast Guard Agency in the first quarter of 2026, a technical anomaly was uncovered within the registry archives for British overseas territories. Among the updated ownership filings for the Esperanza 3, a 68-meter superyacht sailing under the flag of Jersey auditors, identified a highly complex financial transaction. Paper ownership of the vessel led directly to Vanguard Marine Holdings Ltd, a shell company registered in St. Helier. Through 3 tiers of corporate cross-referencing, the ultimate beneficial owner was identified as a British renewable energy billionaire currently lobbying for lucrative offshore wind farm concessions in the Irish Sea. What initially appeared to be a standard tax compliance check escalated dramatically upon the review of the vessel's movement logs and supporting vouchers. Fuel clearance records and port fees from Malta and Monaco the previous summer revealed an unheralded 6-day private voyage across the Mediterranean. Among the passenger manifest exempted from customs inspections under diplomatic privilege was Queen Camilla. Crucially, the breach lay not merely in the voyage itself, but in its accounting methodology. The entire logistical expenditure covering marine fuel and private aviation transfers, totaling approximately $145,000, had not been declared as a personal gift or official state hospitality. Instead, it was converted into an art and heritage consultancy fee, funded through the Windsor Cultural Trust, a non-profit charity under the primary patronage of Queen Camilla. Against the backdrop of UK public sector austerity, mounting inflation, impacting citizens, and heightened parliamentary oversight from the House of Commons Public Accounts Committee, this expenditure represented a critical institutional liability. It constituted a direct violation of the Institutional Financial Transparency Code, established by the Prince of Wales in early 2024. That directive explicitly prohibited senior members of the royal family from accepting corporate perks, logistics, or sponsorships from entities with commercial conflicts of interest regarding Crown assets unless pre-approved by the Royal Budget Compliance Committee. The irregularity triggered an immediate covert protocol. Maritime Registry Document UK 992J was routed directly to Prince Edward, operating in his capacity as head of independent internal audit for the Crown Estate Council. Operating strictly through forensic document analysis, bank statement, reconciliation, and corporate tax ID cross-referencing, without physical surveillance or intelligence assets, Edward's team exposed a major vulnerability in the monarchy's financial governance framework. Prince Edward determined that the transaction was no mere administrative oversight. Routing $145,000 through a charitable entity indicated a deliberate attempt to evade scrutiny by Revenue and Customs HMRC. Under UK law, registered charities enjoy substantial tax exemptions. Blending commercial or personal expenses into charitable financial reporting constitutes a direct violation of the Charities Act 2011. Had this information leaked beyond internal controls, it would have set a perilous legal precedent, threatening the Crown's patronage status across hundreds of UK charities. A granular analysis of the Esperanza 3 logbooks revealed that during the 6-day voyage, the vessel's automatic identification system, AIS transponder, had been deactivated between 11:00 p.m. and 5:00 OM, while navigating international waters between France and Italy. Although officially attributed to a transponder technical failure, Jersey Maritime Records documented an at-sea refueling operation executed by a private supply vessel. The invoice had been settled via a cashier's check issued by a private bank in Geneva. All forensic trails pointed to systematic concealment of funds and beneficial identity. The office of Queen Camilla, managed by administrative advisor Colin, had maintained this accounting arrangement for months without disclosing it to the Royal Budget Management Board. Prince Edward immediately compiled a preliminary evidentiary dossier, designated as File CR 2026 MCA, preparing the ground for an exhaustive forensic audit. The forensic audit led by Prince Edward dissected the sophisticated financial layers engineered to obscure the true nature of the Esperanza 3 voyage. By extracting SWIFT transaction records and Central Bank of Jersey archival filings, Edward and his legal team unraveled the remittance network. The $145,000 sum had not been transferred directly from the energy conglomerate to the charity. Instead, it had been fractured into multiple art exhibition sponsorship contracts routed through 2 cultural service brokerages in Zurich before settling into the accounts of the Windsor Cultural Trust. At Buckingham Palace, legal advisor Colin, representing Queen Camilla's personal administrative affairs, grew concerned as repeated requests for original vouchers arrived from the Internal Audit Department. Seeking to neutralize the threat, Colin attempted to exploit a loophole in the 1996 Royal Financial Regulations, an outdated framework permitting members of the royal family to receive security-related transit amenities without public disclosure if tied to rest and recuperation. Colin secretly drafted a retroactive addendum attempting to reclassify the Mediterranean voyage from an informal diplomatic engagement to an exempt personal recuperation trip. The maneuver failed to deceive Prince Edward. Cross-referencing revealed that merely 3 days after the Esperanza 3 docked in Monaco, the Crown Estate, which manages the UK foreshore and seabed, received a priority petition for geological survey licensing from the billionaire's energy firm. Attached to the petition was a personal letter of recommendation bearing the seal of the Queen's office, a direct breach of constitutional neutrality. The luxury cruise and the economic privileges were clearly linked in a quid pro quo arrangement. What began as an issue of personal extravagance had evolved into an exchange of constitutional influence. Under the guise of arts patronage, the Queen's office, advised by Colin, had established a covert lobbying channel. Every document from aviation fuel invoices and offshore VAT declarations to private meeting memorandums was catalogued, encrypted, and compiled by Edward into an audit dossier exceeding 300 pages. The institutional risk had reached its highest threshold, a policy corruption scandal within the upper echelons of the monarchy. Edward scrutinized the structural evolution of the Windsor Cultural Trust. Established in 2018 to raise private capital for restoring non-museum works within the royal collection, the Trust's operational charter had been quietly amended by Colin in 2022. An added provision, Clause 12C, authorized the Board of Trustees to establish diplomatic contingency reserves to cover the patrons' travel and logistics without requiring approval from HM Treasury. Detailed bank statements from Coutts & Co. revealed that over the preceding 36 months, at least 7 other transactions shared this exact structure, totaling over $1.2 million. Funds were funneled into the trust as anonymous donations from commercial entities registered in tax havens, including the Cayman Islands, the British Virgin Islands, and Liechtenstein. Each entity maintained indirect ties to corporations seeking public resource exploitation licenses or bidding on UK government infrastructure projects. The temporal alignment between these contributions and administrative decisions by the Crown Estate presented undeniable evidence. Edward's cash flow analysis mapped the precise mechanism: corporate entity funds, Swiss brokerage. Swiss brokerage executes sham consulting contract with Windsor Cultural Trust. Right Arrow Charity, covers luxury logistics for the Queen's Office. Speech Right Arrow Queen's Office issues letters of recommendation or facilitates private access to public asset managers. The sophistication of this offshore network lay in its complete circumvention of the Lobbying Transparency Act 2014. No direct representation contracts were ever executed. All terms were couched in metaphors within cultural memorandums. Colin had constructed a legal firewall relying on the independent legal personality of the charity and royal privacy privileges. However, the firewall cracked when Edward cross-referenced the Swiss VAT registration of the Zurich Cultural Brokerage. Through an automated information exchange under the Common Reporting Standard CRS with HMRC, Swiss tax authorities provided a breakdown of the brokerage's shareholder structure. The disclosures revealed that a 40% stake in the entity was held by a trust company registered in Nassau, Bahamas, where Queen Camilla's son, Tom Parker Bowles, had served as a named brand strategy advisor until late 2024. This link dismantled Colin's defense. The $145,000 expense was no longer an isolated audit oversight, but the focal point of a complex network of familial self-interest directly threatening the impartiality of the Crown. With the evidentiary chain fully established, Prince Edward presented the complete dossier to the Prince of Wales at William's private study in Windsor. The gravity of the situation was framed by a highly sensitive constitutional reality. Prince William, as the sole legal heir to the Highgrove estate, a property strictly governed by the Highgrove Trust Act, 1999, fully recognized the legal separation between public and private assets. The Highgrove estate, alongside its sustainable agricultural holdings, operated under total financial transparency, with every pound of revenue reported to Parliament. Unlike William, Prince Edward held no inheritance rights or economic interest in Highgrove. His role was strictly that of an institutional guardian, an objective auditor acting for the stability of the throne. This clear division of interests ensured that Edward's investigation remained entirely neutral and legally unassailable. During the discussion, Princess Charlotte, now 11 years old, entered the study to retrieve land registry documents for her studies in territorial governance. Though young Charlotte was already receiving instruction in constitutional history and royal responsibility. Observing organizational flowcharts, property rights maps, and red-circled figures on her father's desk, she posed no questions, but her presence served as a stark reminder the future generation of the monarchy was maturing under rigorous operational standards. The young princess's early awareness of the weight of the crown reinforced William's resolve he could not permit financial impropriety to undermine the institutional foundation his daughter would one day inherit. Constitutional risk had reached a critical threshold. Should the House of Commons Public Accounts Committee (PAC) discover that a royal charity was serving as a financial conduit for lobbying involving Crown estate assets, Parliament could invoke the Budget Accountability Act. This would trigger a full public inquiry into the sovereign grant, stripping the Crown of its financial autonomy and destroying public trust in the monarchy. William concluded that the only viable path was not a cover-up, but a precise, uncompromising internal institutional intervention. Reviewing Report CR 2026 MCA, William focused not merely on the $145,000 figure or the Superyacht Esperanza 3, but on the integrity of sovereign neutrality. In the UK's constitutional monarchy, the sovereign and queen consort exercise no direct legislative or executive power, relying entirely on supreme symbolic authority. Transforming that authority into a tool for private commercial gain threatened the constitutional legitimacy of the monarchy itself. If this document falls into the hands of the opposition chair of the Public Accounts Committee, William observed, his tone measured and calculated, "We will not merely face a media crisis. We will face new parliamentary legislation restricting all royal assets, including management of the Crown estate and inherited trusts." Prince Edward presented an independent legal impact analysis authored by an Oxford professor of constitutional law. The analysis cited the 1936 constitutional precedent, confirming that any action by a senior royal causing a severe erosion of parliamentary confidence in the Crown's impartiality could prompt the Prime Minister to introduce a power restriction order in the House of Commons. Furthermore, the Highgrove estate where William held sole inheritance sat at the center of public debate regarding land governance and ecological agriculture. Highgrove was not merely real estate, it was the physical embodiment of the sustainable governance model William championed. Should the Queen's office be exposed for utilizing charitable trusts to facilitate fossil fuel energy conglomerates entering Crown Estate green projects, William's credibility on environmental governance would be compromised. William stood and walked toward the map of Crown property allocations mounted on the wall. The interconnected structures of the Crown Estate, the Duchy of Lancaster, and private holdings, like Highgrove, were clearly displayed.
"Edward," William said without turning, "we cannot handle this the way Buckingham Palace did in the 1990s. No covert arrangements, no off-the-record financial settlements. We will resolve this using the exact legal framework they attempted to exploit." The presence of Princess Charlotte in the room underscored the generational stakes. The decisions made in that study were not merely tactical responses to a current crisis, but structural actions designed to safeguard the institution for the future. Recognizing the threat posed by the Internal Audit Department's covert investigation advisor, Colin launched a final legal counteroffensive. He submitted a confidential memorandum to the National Audit Office petitioning for the application of the Royal Privileged Confidentiality Clause across all charitable trusts under the Queen's patronage. Colin's objective was to seal the Windsor Cultural Trust records, rendering them inaccessible even to internal royal auditors. However, Colin and Queen Camilla failed to anticipate the strategic intervention of Princess Catherine. Raised in a disciplined middle-class family with a clear understanding of the British electorate, Catherine possessed a pragmatic perspective, unencumbered by feudal privilege. She recognized that the modern monarchy's survival depended not on archaic immunity, but on public legitimacy and strict accountability. Her parents had instilled in her a foundational financial principle: all public funds must be fully accounted for, and no individual stands above basic accounting standards.
Catherine entered the conflict as a key strategist. She established a confidential channel with the Chief Legal Counsel to the Privy Council and the Public Asset Management Committee, spending weeks reviewing the Sovereign Grant Act 2011, alongside Kensington Palace's internal governance frameworks. Rather than addressing individual misconduct, Catherine authored the Institutional Administrative Restructuring Dossier. This document outlined a comprehensive reallocation of administrative authority. Citing governance efficiency and budgetary transparency, she proposed revoking the Queen's Office's authority over strategic charities and key state schedules, transferring oversight directly to the Office of the Prince and Princess of Wales at Kensington Palace. To neutralize Colin's maneuver, Catherine cited Section 14 of the Public Trustee Act 1925, demonstrating that any royal charity displaying evidence of commercial conflicts of interest automatically forfeited its confidentiality immunity. This legal argument cut off Colin's line of defense, rendering his motion to seal the records legally void. Working directly with Privy Council legal experts, Catherine executed her strategy quietly. She avoided media commentary and maintained a flawless public profile. While behind closed doors at Kensington Palace, she systematically audited every provision of the 2010 Royal Patronage Regulations. Her background provided a distinct advantage. She was uninfluenced by aristocratic conventions, where improprieties were historically overlooked. She viewed royal charities as public trusts, operating under a fiduciary duty to the citizenry. "If we do not clean our own house," Catherine remarked during a strategy meeting with William and Edward, "Parliament will do it for us. And when the public sees $145,000 invoices for luxury yachts during a cost of living crisis, no royal title will protect the throne." In a final attempt to secure political intervention, Colin attempted to approach the Prime Minister's private secretary. Anticipating this move, Catherine had already issued a legal risk memorandum to the Permanent Secretary of the Ministry of Justice via independent counsel. The memorandum highlighted that any government effort to conceal the financial records of the Windsor Cultural Trust would constitute obstruction of institutional justice, exposing the administration to a Supreme Court inquiry. Upon reviewing the memorandum, the Ministry of Justice adopted a stance of strict neutrality, rejecting Colin's requests for assistance. The office of the Queen was left completely isolated legally. Potential political allies withdrew as it became evident that Kensington Palace had assembled an unassailable dossier backed by statutory law and the Privy Council. By mid-2026, Prince William executed the highest legal mechanism available to the heir apparent, invoking the royal prerogative in conjunction with the statutory provisions of the Royal Trusts Act.
Avoid public statements. William initiated a series of decisive administrative actions. He convened directly with the King's private secretary and the chairman of the Privy Council Advisory Committee. Presenting the audit dossier prepared by Prince Edward, William established that Queen Camilla's involvement in covert discussions regarding national energy assets constituted a Level 1 information security risk.
On these grounds, an information embargo was enacted. The red boxes, the official leather dispatch boxes, containing sensitive government intelligence and cabinet reports, were formally restricted from the Queen's office. All state documentation
intended for King Charles III was redirected through a screening unit within the office of the Prince of Wales.
Simultaneously, Prince Edward finalized the Consolidated Master Dossier, designated Corpus Delicti, Project Windsor Transparency. The dossier contained itemized SWIFT statements detailing 12 offshore transactions via Jersey and Zurich, certified copies of sponsorship contracts between the energy conglomerate and the Windsor Cultural Trust, the original maritime logbook of the Esperanza III, complete with the captain's signature verifying Camilla's presence.
A formal HMRC analytical report confirming violations of charitable tax exemption regulations. The institutional trap was set. No room was left for negotiation or emotional appeal. The legal framework was absolute. The offending parties faced the full weight of British statutory law.
To maximize compliance, William invoked a rarely utilized constitutional tool, the Special Budget Control Order of the Royal Senate Council. This mechanism empowers the heir apparent with the concurrence of the head of internal audit to temporarily freeze sovereign grant disbursements to dependent offices if expenditure legality is compromised. The freeze order was delivered to Coutts & Co. on a Monday morning. The operational accounts of the Queen's office were immediately placed under restricted oversight. Any disbursement exceeding $5,000 required a secondary authorization signature from the Financial Secretary to the Prince of Wales. Stripped of authority, Colin was unable to retain private legal counsel or fund external media campaigns. Internal financial controls had successfully frozen the operating budget of the Queen's office. Concurrently, Prince William convened a private meeting with representatives of the Crown Estate. Acting as the future manager of the public estate, William directed the permanent cancellation of the energy conglomerate's geological survey application associated with the Esperanza III. His statement was recorded in the confidential minutes. The Crown Estate will never issue a license to any commercial entity attempting to access Buckingham Palace through the back door. The integrity of public assets is non-negotiable. This action neutralized the energy billionaire's primary objective. Facing commercial failure and potential investigation by the Securities and Exchange Commission, the conglomerate withdrew its applications and severed all sponsorship agreements with the Windsor Cultural Trust. William had eliminated both the internal breach and the external threat. In late July 2026, the final confrontation took place in the Japanese Room at Buckingham Palace, a secure, soundproof space traditionally reserved for sensitive constitutional discussions. There were no media personnel public statements or emotional outbursts. The atmosphere was cold, formal, and strictly judicial.
Seated around the antique mahogany table were King Charles III, the Prince of Wales, William, Queen Camilla, Prince Edward, Princess Catherine, and the Chief Legal Counsel to the Privy Council. Prince William opened the proceedings by laying two black leather folders on the table.
The first folder contained the Corpus Delicti dossier compiled by Edward. Rather than reviewing the entire file, William focused on two critical elements. First, he cited the 2005 prenuptial financial protocol executed prior to the marriage of Charles and Camilla. Clause 8b explicitly stipulated any deployment of royal status to secure direct or indirect financial gain for non-constitutional entities shall result in the automatic forfeiture of personal operational allocations derived from the sovereign grant. Second, William presented financial records proving that funds originating from the energy conglomerate had been routed through the Windsor Cultural Trust and skimmed as arts management fees, landing in a private trust in the Cayman Islands. The ultimate beneficiary of this trust was identified as Lola Queen Camilla's granddaughter via media consulting contracts executed by her son Tom Parker Bowles. The appearance of Lola and Tom Parker Bowles on international transaction records provided indisputable proof, transforming the matter from an administrative oversight into a clear case of familial self-enrichment. Addressing King Charles III and Queen Camilla directly, Prince William spoke calmly, backed by absolute legal authority. "We are not here to debate motives. We are here to manage institutional consequences." William opened the second folder, the Instrument of Voluntary Institutional Power Reduction. Its terms were precise and legally binding. Queen Camilla was required to immediately resign from all 85 public patronages and charitable organizations. A 70% reduction in personnel funding was imposed alongside the immediate termination of advisor Colin and the Queen's personal advisory staff. All official royal representation duties at key state functions were transferred to Princess Catherine. The Queen's office was permanently barred from accessing constitutional documents and attending Crown Estate meetings. William delivered a firm ultimatum. Should both instruments fail to be executed immediately, the complete corpus delicti audit file would be submitted to the House of Commons Public Accounts Committee and the Supreme Court by 8:00 a.m. the following morning. Queen Camilla remained silent, her attention moving from the swift transaction records to the Prince of Wales. The financial trails, Colin's signatures, and the contracts signed by Tom Parker Bowles were all verified by official audit stamps. King Charles III looked at his son, absorbing the speed and precision of the legal strategy William had executed. As a constitutional monarch, Charles recognized the definitive reality. Should these findings reach the Supreme Court, his reign would face an insurmountable constitutional crisis. William, the king, said quietly, "Is this truly necessary for the stability of the institution?" "It is vital to the survival of the throne." "Your Majesty," William replied without hesitation, "we cannot ask the British public to accept economic sacrifice while the top of this institution operates like an unregulated private enterprise. The decision rests with Your Majesty." Princess Catherine slid a Parker fountain pen across the table toward Queen Camilla. She spoke no words, but her posture reflected the absolute unity of Kensington Palace. Queen Camilla took the pen. Her hand trembled slightly as she signed the final page of the Instrument of Voluntary Institutional Power Reduction. Once completed, King Charles III received the document and signed it in his capacity as head of state, formally enacting the administrative decree. Prince Edward retrieved both executed documents, placing them into a leather case sealed with the official stamp of the Royal Audit Department. The meeting concluded after precisely 42 minutes. Without raised voices or dramatic gestures, an administrative restructuring had been completed within the quiet confines of the Japanese room. The following morning, no press releases or news bulletins were issued by Buckingham Palace. Terms such as scandal, sanction, or purge were entirely absent from official channels. Yet the execution of the decree proceeded with total operational efficiency. At precisely 9:00 a.m., administrative access credentials for advisor Colin and 4 senior aides were revoked at Buckingham Palace. All files, computers, and physical archives within their offices were sealed and transferred to the Internal Audit Department under Prince Edward. A brief internal memorandum was circulated to royal staff announcing a restructuring and streamlining of administrative operations within the Queen's office to optimize public expenditure. On the official royal website, the list of Camilla's charitable patronages was quietly removed. In its place, an administrative update announced that Princess Catherine would assume the role of chief overseer for all Crown heritage and cultural funds. Queen Camilla was institutionally isolated. Her independent foreign tours were cancelled, replaced by a strictly controlled domestic schedule. While she continued to appear alongside King Charles III at formal state ceremonies, her administrative authority, policy influence, and independent financial resources were entirely dismantled.
Colin received his termination notice that afternoon, bound by a perpetual non-disclosure agreement (NDA) enforcing total forfeiture of pension rights and criminal prosecution under the Official Secrets Act 1989 in the event of any breach. No media interviews were granted, and no details regarding the Esperanza 3 incident leaked to the press. At Kensington Palace, Prince William sat at his desk overlooking the Memorial Garden. Beside him, Princess Catherine reviewed the draft budget for the 2027 financial year, a fully transparent financial model built to withstand rigorous parliamentary auditing. Charlotte, now 10 years old, entered the room and placed her constitutional history assignment on her father's desk. William offered a subtle smile, his expression reflecting the quiet discipline required of an institutional leader. A new structural order had been established. The future monarchy under William was designed not around personal sentiment, familial compromise, or historic privilege, but as a modern state institution, fully compliant with the law and prepared to excise any element that threatened the survival of the crown. Prince Edward completed the final archival report, applying an executed stamp to the master file of Operation Windsor Transparency. The dossier was deposited into the maximum security vault of the Privy Council, joining the unreleased institutional archives of the United Kingdom. The throne had been secured not by public relations or displays of power, but through the decisive application of legal authority. The crown survived, adapted to a modern world, demanding absolute transparency and total institutional accountability.